Hi, I'm Dee. I'm a paralegal at Wang Law Office. We're located at 3625 Main Street, 3rd floor, Flushing, New York, 11354. Welcome to our first online podcast. Today we'll be talking about President Obama's Deferred Action Program. If you have more questions at the end of the show, please feel free to call us at 718-353-9264. Please be aware that this podcast does not create an attorney-client relationship with any listener. In other words, even though we are a law firm, we're not your lawyer. If you need personalized legal advice, please contact us. Now, I'd like to introduce Victor, a lawyer at our firm. Hi, Victor.
Hi, everyone. Hi, Dee. Welcome to our podcast. Like Dee said, we are going to introduce Obama's Deferred Action Program. People that qualify for this program will be referred to as dreamers in this podcast.
Victor, can you explain the Deferred Action Program to us briefly?
Sure. The Deferred Action Program is a temporary solution to young people who, through no fault of their own, are without status. This would allow these dreamers to receive 2 years deferred status during which they can work, apply for driver's licenses, and not worry about being deported. The Deferred Action Program focuses on low-priority individuals who can and do contribute to society. As President Obama said, these dreamers are in all senses Americans, except for the fact that they arrived here illegally when they were children.
What does it take to be a dreamer?
There are a few criteria to be considered a dreamer. Dreamers need to be under 16 when they arrived in the United States. They also need to be under 31 years old as of June 15, 2012. They need to have been in the United States for over 5 years and be able to prove that as of June 15, 2012, they were physically in the United States. Dreamers also need to fulfill at least one of the following criteria. They have to be either in school right now, have a high school diploma, have a GED certificate, or be honorably discharged from the Army. Finally, dreamers should have no felony offenses, no significant misdemeanor offenses, have less than 3 non-significant misdemeanors, and they cannot be a threat to national security or public safety.
Most of that sounds pretty straightforward, Victor. Let me ask you, what are the differences between felonies and significant versus non-significant misdemeanors? And how do you determine if you are a threat to national security or public safety?
Well, a felony is a crime that carries a sentence of more than 1 year jail time. On the other hand, a significant misdemeanor carries a sentence of a year or less, and it involves violence, sex, burglary, theft, DUI, obstruction of justice, bribery, hit and run, firearms, or drugs. All other misdemeanors fall under non-significant misdemeanors. However, any conviction, arrest, or other juvenile delinquency cases will be considered to determine whether you are a threat to national security or public safety. If you have any sort of criminal history, you should talk to a lawyer at once.
So, any type of criminal or juvenile case that you may have been convicted of, or cases that have been adjudicated against you, can affect your application?
That's right. That is why you should always reach out to an immigration lawyer that also handles criminal cases to evaluate your situation if you have had any contact with law enforcement or have any sort of criminal history. Past mistakes made when you were young can still affect your application today.
I'm sure that a lot of dreamers have already applied for other forms of relief, and some of them may already have a removal order due to a previous failed application. For these people, are they still eligible?
This is where the Deferred Action Plan is great because removal orders or failed applications in the past do not affect your eligibility for deferred action. Deferred action requirements are straightforward. The goal is to provide young adults who can and will contribute to society a chance to stay and work in the U.S. legally.
Okay, Victor, how about this scenario? I entered the United States on the day of my 16th birthday. Or second scenario, I turned 31 years old on June 15th, 2012. Would either of these scenarios make me ineligible?
Unfortunately, yes. You have to be under 16 at entry and under 31 as of June 15th, 2012. You must fulfill both requirements.
Okay, can I apply for deferred action now, as in today?
Only those in proceedings or facing imminent removal can request deferred action for right now. However, in these cases, there is no form, and you must consult with an attorney to do this request. If you are not in proceedings or not facing imminent removal, you will have to wait until August 15th, 2012 to apply with USCIS.
So since the form isn't ready, everyone has to wait?
Well, no. People who feel that they qualify should immediately start gathering evidence and speak to an attorney to see if they qualify for the program.
So what type of documents would a potential dreamer need to look for then?
They should look for proof of age, such as a birth certificate. They also need proof of entry into the US. This would include an I-94 card or an old passport or plane ticket stubs to show that they entered at a young enough age as required in this program. Also, if there are no record of entries, you can use school records such as transcripts, letters from the school, or report cards. All you need to do is show some sort of document showing that you were in the US prior to turning 16. You also need proof that you are still in school, or have graduated high school, or have a GED certificate. Any other evidence that shows that you were in the US continuously and on June 15, 2012 would be required as well. Naturally, any documents relating to previous arrests, convictions, and immigration proceedings should be gathered as well.
Wow, that sounds like a lot of files to prepare and gather for this application.
Yes, there's a lot of documentation that can be gathered, and I would recommend that after gathering these files, you should go to a lawyer and have the lawyer review them to make sure that no information is missing. Because of the wide scope of possible files that can be used for your application, it's best to try to be as thorough as possible. If you want to apply as early as possible for this program, your lawyer would have to review the documents before August 15, 2012.
So Victor, who would you recommend to go to for help?
Naturally, ourselves, Wang Law Office.
Ah.
We specialize in immigration law, especially crimmigration, defending those with criminal convictions suffering immigration consequences. Also, I would recommend that all dreamers throughout the United States go to a reputable lawyer or community organization, and to avoid all immigration consultants and notarios. There have been warnings on the USCIS website about immigration consultants and notario scams. Therefore, only go to reputable lawyers and community organizations. If you have a removal order or any prior arrests or convictions, it is highly recommended that you go to a lawyer with both criminal and immigration background.
Thank you so much, Victor, for your insights.
You're welcome.
Well, this concludes our first podcast. Once again, if you have any questions, please feel free to contact us at 718-353-9264. 718-353-9264, or via our website, www.wanglawoffice.com. www.wanglawoffice.com. Please note that any questions posted on our website or left to us do not create an attorney-client relationship. If you enjoyed this podcast, please like us on Facebook and send us a tweet on Twitter. Thank you for listening!